Third-party funding in the UK is still a relatively immature market. It's still relatively unknown, or at least not fully understood. At Fox Williams, we were keen to promote a debate about the future and role of third-party funding and to increase its awareness, both amongst the legal community and also among potential litigants. We therefore recently commissioned a report called The New Thing, done by Jures. We were surprised at the degree of interest and attention that report has received, both among the legal community, among journalists, and also among lawyers overseas. As part of furthering that debate, we have brought together a panel of industry experts, a combination of representatives of third-party funders, practitioners, and journalists and academics who've been researching this market. We're going to be looking at a number of topics. For example, does third-party funding in fact promote access to justice? And what is the impact of the recent review on civil costs by Lord Justice Jackson on the third-party funding market going forward? We hope and expect the debate to be thought-provoking and informative.
My name's Susan Dunn. I'm the Head of Litigation Funding at Harbour Litigation Funding. I'm a solicitor who moved into litigation funding back in 2002 when this was a very new product, working primarily with insolvency practitioners and insolvency lawyers who had a clear and immediate need for funding to try and realise recoveries in their estates.
My name's Neil Perslow. I'm one of the founders and a director of Theorem Capital Management. We're a third-party funder. We launched at the beginning of 2009 and are now probably one of the most active in the UK.
I'm Gavin Foggo from Fox Williams. I'm a partner in our commercial litigation department, and the reason that we're interested in commercial third-party funding is to give extra options to our clients, to enable small and medium-sized businesses who aren't otherwise able to fund meritorious cases to do so, and also for larger clients who may be able to afford to litigate, but who would, for other reasons, perhaps to keep the litigation off the balance sheet or mitigate risk, to do so as well.
I'm Kerry Underwood, solicitor, Chairman of Law Abroad plc, and my interest in third-party funding and funding generally is for ordinary people in the things that crop up in many people's lives.
My name is John Robbins. I'm a freelance journalist and I'm director of the legal research company Jures. I'm also author of the report. My interest is in how third-party litigation funding will shape the legal services market.
I'm Dr. Angus Nurse from the Law School at the University of Lincoln. I'm a research fellow in compensation culture, which makes me, I suppose, a socio-legal academic.
I'm Malcolm Stewart. I was a third-party funder between 1998 and 2006. I'm now semi-retired and I am working on my PhD for third-party funding of commercial litigation.
Lawyers will realise that from a compliance viewpoint, it's important to consider third-party funding because they're professionally obliged every time they take on a piece of litigation to advise the client as to the funding options.
The Jackson report is the most woefully written report in the history of the law. It's a truly appalling document. Unfortunately, I know virtually every word of it.
I think compulsory regulation is inevitable in today's world of increasing regulation.
Insurance companies go bust, banks go bust, litigation funders will go bust. It's inevitable.
It is also the role of the solicitor when advising their clients about whether their case A is any good for funding, B whether the funder is any good for the funding. So let's not absolve the advisor from this role.
There's a legitimate purpose to regulation here, which is to help nurture a nascent industry as well as protect the client.
We invest hundreds of thousands, sometimes millions of pounds in cases. It simply isn't in our interests to walk away from things.